in January, Toyota flagged it would be implementing forced redundancies, which would impact around 350 employees. Well, those workers were told of their fate earlier this week. They'll receive 4 weeks' pay for each year of service, capped at 90 weeks. But it's how those workers were chosen to face the axe that has some pretty interesting lessons for business. Joydeep Hoare is a workplace lawyer and the managing principal of People and Culture Strategies joins me in studio. Joydeep, good morning to you. There seems to be a question about whether these dismissals were in fact lawful at all. Is there actually any rule book when it comes to implementing redundancies?
Yeah, it's a good question. There's certainly recognition that if you're going to select people for redundancies, you need to have objective selection criteria. And so if, for example, you as the employer were looking at issues such as the fact that employees were pregnant or were from particular racial backgrounds or below or above a particular age, that would automatically breach discrimination legislation, and so those dismissals would be unlawful. Where it starts to get a little bit more interesting, and what we're seeing in this particular case, part of the controversy, is the extent to which an employer can rely on performance-based criteria in determining people for redundancy.
Because that was seen as quite subjective.
Absolutely.
Yeah.
And from an employer point of view, I guess they would say, well, naturally, we want to keep the people who we rate as being the better performers in our organisation. From the individual employee's point of view, naturally, performance is always so subjective. Very few people would necessarily acknowledge, if they're seen as an underperformer by their employer, that they are in fact an underperformer. And so if that's the perception that they have of their employer's assessment of them, naturally they're not going to be too happy if that's been used as the basis for them being exited from the organisation.
So from what you saw of the details of the criteria that Toyota Australia was using, did you find that a lot of it was subjective? Was there enough objectivity in there, or can you combine the two and still have a problem, you know?
Yeah, I think if you were using purely objective criteria, you'd look at length of service, for example, and hence a lot of employers will use that kind of, last in, first off, or something along those lines. But again, the difficulty is the employers would say, we've had a performance management regime, so we do appraisals, for example, for people once a year, twice a year. It's not as though we're taking people by surprise. So it's not actually that subjective. If someone disagrees with how they've been assessed, there's things that they can do internally. It's not actually that uncommon. So most employers that we'd be working with in developing a matrix for selection criteria would focus fairly heavily on performance-based criteria. And what we'd be encouraging them to do is just make sure that a person can't turn around and say, well, you never told me that I was seen as an underperformer. This is the first time you're effectively giving me that feedback.
There's, it seems like a challenge from unions brewing on this. That, in fact, the company's saying that the unions knew of the selection criteria they were talking about back in January. So do you think we're actually likely to see any kind of successful legal action? Yeah,
I think one of the threats that's been made by the unions is that they're going to bring an adverse action claim. Now, that was something that was introduced by the Fair Work Act, and it was a new provision whereby an employee could challenge a termination if they could prove that the reasons for the termination was something to do with their union membership, the fact that they'd asserted a workplace right, or any of the traditional discrimination grounds like sex, race, age, disability, etc. So I think what we might see is the unions bringing a claim, or certain individuals bringing a claim, that they were selected for redundancy for reasons that included the fact that they might have been a union delegate or members of the union. Now, the difficulty for the employer, if those claims are brought, is that the onus will shift to the employer to disprove that that was in any way a reason. So they're notoriously difficult cases to defend. There's not a huge amount of precedent on them in Australian law because it's only been in place for a few years.
Do you think then that the relationship between employer and employees is being strained or even damaged by Fair Work? This is the big question, isn't it? Because a lot of the commentary around what's happened with Toyota this week points to the fact that Toyota was always considered to be a very good employer. The relationship even between the unions and the company has always been very conciliatory, unlike, say, the very long, tough history between the unions and, say, Qantas as a different employer.
Yeah. I think when you're looking at removing 300 plus people from your organisation, you're going to come under pressure. And I don't think any employer in this country would rub their hands with glee at the prospect of letting go of that many people. And certainly organisations that do pride themselves on their culture would not be making those kinds of decisions lightly. The Fair Work Act is by no means perfect. There's no question about that. Work Choices was by no means perfect. Legislation that deals with IR can't be perfect, I think, by definition. I do think, though, that it does get blamed for a lot of issues that are happening at the moment. And the reality is that there are economic pressures that a lot of organisations are facing. There's cultural challenges. Manufacturing in Australia is challenged. I think everyone recognises that, certainly on the employer side of things. I don't necessarily know whether it's fair to say that had there been a completely different industrial relations regime, Toyota wouldn't necessarily have done what they have done.
Yeah.
I think they would say that we've done the best we can in difficult circumstances, as would most employers.
Just a really quick one to finish. I think I've only got 30 seconds, but one of the other major issues that's been brought up is that the tactics seemed aggressive. The workers were kind of tapped on the shoulder, taken on a bus, kind of escorted elsewhere, given a green folder, and they were off.
Yeah.
What did you make of all of that, and whether there's kind of considerations? Really, this comes back to culture and how things are managed, and also how you manage the people that are left behind. That's always an issue as well.
Yeah, it is. It is a big issue. There's no easy way to do it. That's the reality. I mean, if you're sacking someone as an employer, it's not a good news story ever. In this case, I guess employees are going to get some financial compensation that's not insignificant. There is no easy way to do it. I understand that it's not the best of looks. Transporting people to this off-site location, it seems a lot more sinister than perhaps it could have been. I'm sure they had their reasons as to why they did what they did.
Joy Deport, thank you so much
Thanks,
for joining
Brooke.
us from People and Culture Strategies in studio with me this morning. Coming up, the good